Hello. Hello to all attendees. Hello, I'm Professor Michael Hayes from the University of Baltimore School of Law, and I'd like to welcome you to this afternoon's webinar, which is a look at how the COVID pandemic is affecting the workplace and how employment law applies. Over the next hour, four very knowledgeable and experienced panelists will share their understanding of the legal landscape around COVID-19 and workers' rights, and I'll serve as a moderator for that discussion, and as well as the moderator for the attendee questions a little later in the webinar after our panelists have had a chance to speak. When we think about employees working the pandemic, of course, we think of frontline health workers, also from our own experiences, grocery delivery services and public transportation. We should also think about the risks they face in going to work each day. How are their employers protecting them? What happens if one of them becomes infected with COVID? What is the employer's responsibility if that happens? In some sectors, whistleblowers have exposed employer malpractice. What are the risks they face in stepping forward? And what are the best and most forward-thinking employers and their lawyers, who you'll hear from, doing to support their employees? We're looking forward to your questions. You can submit them using the Q&A function on the Zoom dashboard, and we'll get to as many of them as we can. And my able student, Mr. Cooper Jarris, will assist me in keeping track of your questions and addressing them. Before we begin, I do want to tell you about our next webinar, which will be a week from today, Wednesday, August 5th, The Calm Before the Storm, and that is a look at pending COVID-related litigation. And we have some wonderful panelists for that discussion also, so please check it out by following the link to the homepage on our website. And now, turning to this afternoon's discussion, let me introduce our panelists. Ms. Tara Butcher is an Assistant General Counsel at Allegis Group, actually the Aerotech division of Allegis Group. Aerotech, well known in Baltimore, because the owner of the Ravens, Steve Bisciotti, founded it. And it's based in Baltimore, has more than 19,000 employees, $13.4 billion in revenue, and she advises company leadership on an array of workplace issues, including federal and state discrimination laws, internal investigations, wage and hour issues, personnel policies, and terminations. Erin graduated from the University of Baltimore Law School, former student of mine, in 2007. Then we'll hear from Ms. Jessica Chu, who is the Chief of Staff and Special Counsel to the Amalgamated Transit Union's International Office, represents more than 200,000 public transit workers, also school bus drivers, inner-city bus drivers in the United States and Canada. Ms. Chu earned her JD from Northeastern University School of Law in 2007. Then we'll hear from Ms. Donna Glover, an employment law attorney with the Baltimore firm of Baker Donaldson. She's a 2006 graduate of University of Baltimore Law School and assists clients with matters related to day-to-day management, minimizing exposure, charges of discrimination and wage complaints, and various employment-related litigations. And she's also been a presenter at numerous webinars in the past year. Professor Nancy Modisett has been on the faculty of the University of Baltimore Law School since 2007, where she teaches employment law, torts, and lawyering skills. She is an expert on whistleblowing, which is what she'll be talking about tonight, and she co-authored the 2015 book, Whistleblowing, The Law of Retaliatory Discharge. Thank you all panelists for being with us today. I know you're very busy, and we appreciate your being here. So as I said, we'll begin with Ms. Tara Butcher, and she's advising, basically within her organization, they send employees to all kinds of employers, and this makes for a very interesting practice, but also a lot of issues. So with that, I'll turn the floor over to Ms. Butcher, please.
Thank you, Professor Hayes, and thank you for everyone who is participating and those who asked me to participate as well. It seems these days that my life is around it. COVID-19, the pandemic, is something that I cannot escape, particularly when, as Professor Hayes said, I work at Aerotech. We are the largest privately held staffing company in the United States. We have probably over 10,000 clients, and any given year we issue W-2s for over 400,000 contractors. So you can just think the number of people that we may have at any number of clients in different industries, from auto industry to finance to manufacturing. Those are all the different areas. I mean, I can't even name all the different areas. We even have people right now helping with creating COVID tests. And so the questions always come up, whether just regardless of what the industry you're in, is, you know, how do we get people back to work? There's been a number of people, particularly in clients, that have worked the entire time. The entire time they've had they're essential workers. But then we know that the states started opening up in May and June. And so then clients had to start thinking about, what's the return to work plan look like? What does that look like for them? And for a lot of our clients, that has been very much focused on COVID testing. And so, you know, while in the beginning it was focused on just kind of figuring out what do we do in terms of everyone working remote and what does this COVID-19 mean, then it became, okay, now we know about COVID-19, but we still want to get our people back to work. So how do we do so safely, taking into consideration our obligations as an employer to maintain a safe work environment for our employees, and taking into consideration the guidance from the EEOC and CDC and other places such as that. And so, you know, for me, and my other colleagues that I work with, that has, I'm so sorry, hold on one second. I'm so sorry. This is why working at home is, because I'm sure you heard my 3-year-old in the background. I'm so sorry. But part of that is, okay, you want to get them back to work. You want to get them back into the workplace, and you want to do so safely. And what does that look like? And so for a lot of our clients is, we want to do COVID testing, whether it's we want to do COVID testing on our currents, or we want to do COVID testing on any new contractors, as we call them, or temporary workers coming into the workspace. And what does that mean? And so you can't just say, okay, let's just go ahead and give everyone a COVID test. There's guidance out there in terms of how do you do that. The first and foremost, and I'm sure you've heard it on the news, you know, all the different kind of COVID tests, the antibody tests, all these different things that you can do, and all the different type of tests that are out there. And that's where the FDA is involved, because the FDA has, quote, approved certain COVID tests. And so it's called emergency use authorization. So they haven't gone through the full FDA approval process like any other drug, but they have gotten this emergency use authorization. And so there is some data to show the efficacy and the reliability of those tests. And so the EEOC and the CDC says, if you're going to do some testing, make sure you use one that is subject to the emergency use authorization, because that's accurate and reliable. Because quite frankly, why even do the test if it's not even accurate and reliable? Another thing they've talked about is antibody tests. I'm sure you guys have heard on the news, like everyone else, you know, antibody tests, it's a way to see if you've been subject to you've been infected by the virus, or you still have, if you have immunity, etc. Well, one thing I can tell you is that the CDC and the EEOC have said, don't rely on that. That's not a reliable tool for a return to work. So while you may hear on the news all these grand developments in the antibody world, it's still not something that's safe and reliable to use as part of your return to work process. So that's not something you should be making decisions on in terms of whether or not someone is eligible to return to the workplace. So that's that. And then also the CDC, I feel like every week they're coming out with new guidance in terms of what is the best strategy for getting people back to work. Is it, you know, a test-based strategy, meaning doing COVID tests, and in what situations does that make sense, versus should you be doing a symptom-based strategy. And so literally the CDC issued some guidance, I think it was July 17th, once again changing their guidance in terms of, okay, if someone has tested positive for COVID, at what point can you take them out of isolation and return them to work? I won't go into all of the details, but I will tell you that it does make it difficult. I'm sure Donna and others can say on this call to know what the best guidance is to give your clients, because it's a moving target, quite frankly. I mean, the most recent guidance now changes. For example, before you had to be without a fever, without use of medication for 72 hours. Well, now it's, it only has to be 24 hours. The other thing they talked about is, before it was you have to be without any respiratory symptoms in order to come back to work, or now you have to be free of all COVID-related symptoms. And what makes it even more contradictory is that individuals that may have had to self-quarantine because of possible exposure only have to be out of work for 14 days, where individuals who actually tested positive and had symptoms could come back after 10 days, in addition to no COVID symptoms and no fever for 24 hours. So it can definitely be difficult and sometimes stressful for an employer to kind of understand, because it is a moving target. Same with the EEOC. I mean, the EEOC, I think, has given really good and detailed guidance to help in terms of what is reliable, what you should be doing in terms of the actual testing itself, the fact that you can do it as a part of a screening process as long as there's a conditional offer has been made, that you can do it on current pursuant to the ADA. That is medical information, so you need to make sure that you're holding it in confidence, just like any other medical information, and keeping it separate from a personnel file. And you need to be asking questions about who is actually having access to that information. So the EOC has also issued some guidance, I think, which I have found very helpful, and I think other employers have found helpful. But I think as things continue to develop, I think those things are always changing. And so you can't really, as an employer, just have, here's our plan, here's how it's going to work. You really have to be flexible and nimble and know that we're in a time of uncertainty. And that's something that I think I've continued to share with my business partners, who sometimes come to me and say, our clients want to do this, or they want an answer right away, or they want some kind of definitive answer, but there's so much gray area that I've actually had to get more comfortable with. I just got to make the best decision and provide the best guidance based on the information I have in front of me right now. And that may not be proof. In the end, it may still lead to a claim, or it may not necessarily get us out of hot water, but I can only do and provide the guidance that I have in front of me, just like Dr. Fauci and everyone else is doing so based on what they know here and right now. And so as I follow up, as I kind of close, I guess I would just say, the one thing I've learned about all of this is, check your resources, stay up to date. But in the end, I mean, really, it's just using your best judgment and experience to give the best advice you can in a time that's uncertain for everyone.
Thank you very much, Ms. Butcher. And so I think that was very good, excellent, really, in explaining how to advise employers in this time. Now we'll switch a little bit to how do you represent employees in this time, and that would be through a union. And for that, we're very lucky to have Ms. Jessica Chu, and she'll explain what she's been doing with her client, the Amalgamated Transit Union.
Thank you. And I'm happy to be here to speak about the COVID-19 pandemic and its impact on our union. I think I'm going to probably bring a little bit of a different perspective to these panel speakers today, simply because we are a union. And as Professor Hayes stated, we represent about 200,000 transit workers in the United States and Canada. Just to give you a little bit of background about our union, we have approximately 250 local unions, which serves as the designated collective bargaining representative of our members. And what that means is that our locals are tasked with negotiating the collective bargaining agreements, which covers core working terms and conditions. And they're tasked with enforcing those terms where there's a dispute between the employers and our unions. Our employers are actually public transit agencies, they're private contractors. So we are governed by various set of laws depending on the circumstances. So that could be federal, state, and local laws. Since the pandemic began, transit workers have really been on the front lines. They are essential workers that have been moving other essential workers on the front lines. And for example, we're talking about healthcare professionals that rely on public transit to get to the hospital, or patients who are seeking medical care. So there really isn't the option of working from home for our members. Our bus drivers spend extended periods of times their working day in a 40-foot enclosed bus, and even smaller for our paratransit vans. So on a typical day, there's no such thing as social distancing the way passengers board and ride on buses. They are at increased risk of exposure. And as we know, not only is the virus spread through respiratory droplets like sneezing and coughing, but also aerosol transmission of the virus, which are even smaller particles that carry a viral load. Our members also frequently touch surfaces such as steering wheels and tools to our mechanics on the transit systems. And on top of all of that, it's our position that these buses, they've really been made and purchased and put into service with inadequate fresh air, dangerous airflows, and poor filtration, which obviously exacerbates the effects of a pandemic on our members. So really, these circumstances are very unique. They present very unique dangers and hazards for our members. So just to illustrate, we've had more than 80 members pass away from COVID-19. We've actually have about 1,500 confirmed cases among our members. And these are just confirmed and reported cases. I really do think that the numbers are likely much higher. So I wanted just to talk a little bit about what we did as a strategy to confront the pandemic and to maximize, safe health and safety conditions for our members. Initially, we really did see a lot of inaction or lack of direction from the transit agencies. So we knew we had to be proactive and get our concerns out there and to push for how to make transit safer for not only our members, but also the riding public. So we launched what we kind of termed a Safe Service Now campaign. And it really was a multifaceted faceted strategies, which included collective bargaining, putting pressures on local and national elected officials, mobilizing our members and allied ridership groups, as well as educating and training our members, and in particular on their legal rights. And through this, our two main focuses were on economic security, because we knew massive layoffs were on the horizon if, with the decrease of ridership and revenues that transit agencies are receiving. And also just to maximize the health and safety of our members. So to really get to that outcome, we as a union needed to have a voice and be part of the decision-making process alongside with our employers and the transit agencies on these matters. So I'm going to just kind of go over a few of our top safety demands and give you an example of where we successfully procured or received PPEs from the agencies. So our top health and safety demands were obviously to increase PPE and correct these airflow problems on the buses. We did believe that CDC, they issued guidance specific to transit agencies, but we felt that it fell short of how we know buses are manufactured, how airflow happens on a bus, and the necessary PPEs required to keep our drivers and our members safe. So we wanted to go above and beyond what the CDC was saying was necessary. We also pushed for pandemic leave, and this is before the Families First Coronavirus Response Act was enacted. But we did push through bargaining pandemic leave for anyone who was showing symptoms or was exposed to cases or had family obligations due to the pandemic. Another part of our top safety demands was rear door entry, because many times buses actually load from the front, which would bring passengers right up through the front and right next to the bus operators. So we pushed for rear door entry because a lot of times these 40-foot buses have two entryways. And fare elimination, because a lot of times the fare box was right next to the bus driver, requiring people to stand right next to the bus drivers. Also, we pushed for strategic continuation of service to avoid overcrowding. What we saw was a massive curtailment of service, but we wanted the exact opposite to happen so that we can ensure that there's not overcrowding on our buses. Limiting passengers to achieve social distancing, and requiring passengers to wear masks unless there was a medical condition for not doing so. And the other one is a fully paid on-site testing and health surveying of members going in and working. So I'm just going to quickly show you one example of a campaign that we did in Olympia, Washington. And I will hopefully get this up. Can everybody see this? I just want to make sure. Did everyone see that okay? Okay, so this is part of a picture petition that the ATU local there, Local 1576, started in Olympia, Washington, and we represented workers of the Gray Harbor Transit. And this picture petition was really powerful. These faces that you see along the sides of the petition are workers and members of our local. In the beginning, the transit agency was not providing PPEs to our members, and our members had no access to face masks, gloves, hand sanitizers, things needed to protect them against the virus. So this picture petition was launched. It was submitted to the commissioners of the transit system. It was amplified in public places and on social media. And alongside these efforts were a call-in campaign to put pressure to personally call the commissioners in order for them to push for them and advocate for the workers to provide these top safety demands. Less than 3 days later, the local there received a call from one of the commissioners, and a few days later, they actually got all the necessary PPE that they needed. And in addition, they initiated regular meetings with the union to address other COVID-related safety concerns. So I just wanted to show you some of the petitions and the mobilization that was happening with our locals. And I have a few minutes left, so I'm just going to kind of cover some other aspects and components of our responses, which, I mentioned collective bargaining. Of course, we were negotiating MOUs, which are, short for memorandums of understanding concerning hazard pay, premium pay, because in recognition of, our members putting their safety on the line to continue moving people to critical jobs. Also, part of our strategy was also to create pressure on Congress, which, we had a vital role in passing the CARES Act in a provision that provided $25 billion to the transit industry. And that was earmarked specifically for operating assistance, which paid for wages and procurement of PPEs. And this really was a lifeline to us because we knew we needed to do something and Congress needed to act in order to reduce the number or mitigate against the layoffs. As of right now, we have about 18,000 members laid off, but I think that would have been much, much worse had Congress not acted. And unfortunately, 10,000 of those 18,000 are school bus drivers. We're currently pushing for the next COVID bill to include $32 billion for mass transit and additional money for motor coach industry as well as school bus industry. And lastly, I talked a little bit about educating our members. Specifically, we launched an educational piece of this campaign on educating our members on their right to refuse unsafe working conditions. And the two laws I'm going to mention are probably a bit obscure to you, but they mean they're tailored and specifically applicable to our members, which is the National Transit Security Act, as well as the Surface Transportation Assistance Act, which both of which actually include whistleblower protections for employees of public transportation agencies and commercial vehicle workers. So what that entailed was making sure that our employees understood that employers have an obligation to provide a safe workplace, and they have a right to refuse unsafe work if they have a genuine fear of catching COVID-19. That fear is reasonable based on actual facts and reliable science, and the employee has asked his or her supervisor to minimize or eliminate the hazard, and ideally doing so on behalf of the employee and his or her coworkers, and that the employer failed to minimize or eliminate the hazard. So with that, I would just say, we had a success story in Mobile, Alabama, where 95% of the workers asserted their rights due to a uptick in cases there, and they just felt that it was unsanitary conditions on the buses. And the Wave Transit in Mobile actually halted the service to address their concerns. So these are having real impact on how transit systems are operating. So I'll just close with this, which is, we have a lot of work to do. There is certainly an uptick in cases in many parts of the country, especially with premature openings. But we do hope that these are solutions that will just not address, the current pandemic, but also guard against future viral threats, and protect the future of public transit, which is very important.
Thank you so much, Ms. Shu. And we may be able to come back to you for some more information later. But now I'd like to move on to Ms. Donna Glover. And our first two speakers, well, Jessica Chu also talked about premium pay and so on. But there's a lot of emphasis on safety and health. But of course, there are other issues that employers have to deal with, many of which cost money. And so I wanted to turn the floor over to Ms. Donna Glover to talk about even workers who are working remotely and the leave laws and all these issues that that you've been advising your clients on. So please, the floor is yours.
Thank you, Professor Hayes. Happy to be here and spend some time with everybody on the call. I'm going to talk about three things. One is remote work. One is layoff notice obligations under federal and a new state law in Maryland, and the obligations that employers have under paid leave. I'm a defense attorney, so I view this as the advice I give is, obviously making sure employers are following the laws, which I think also is a through line to making sure we're doing the right things for employees. So I see my practice as a balanced approach. And so let's talk about remote work first. We know that everybody transitioned pretty quickly to remote work. Folks have been on remote work in some cases for 5 months. The state and local governments have, in some cases, not in all jurisdictions, have acted with respect to, if I'm doing business in that state with a remote worker, do I have to pay taxes? And so from a state and local tax perspective, for example, DC has said that during the mayor's order regarding the pandemic, no, a remote worker in DC would not cause you to do business in DC and to pay those corporate and local taxes. However, no jurisdiction, to my knowledge, has stated whether or not if a remote worker is in, for example, the district or in Maryland from another state, are you obligated as an employer to comply with those state leave laws and leave rights? And DC is a specific example I point to because in DC, you do not have to have a physical location to be a covered employer under many of those laws. Their thresholds are based on how many hours does the employee work in the district, typically more than 50%. So it's a conundrum right now for employers. How long is remote work before you're actually doing business in the state? And I think it's a trend to keep your eyes on. as this develops, because if your business operations change and this becomes a way you practice business, then you are probably doing business in that state and will have to get into compliance with all of the various laws. So that is sort of a trending topic that I get a lot of questions around as employers continue to work through the issues regarding return to work. The other issue I've dealt a lot with, of course, is reductions in force and what employers' obligations are with respect to that. Of course, there is a federal law, which is the Federal Workers Adjustment, Retraining, and Notification Act. That requires larger employers, 100 or more full-time employees, to give 60 days advance notice of the effective date of the layoff and continue pay and benefits during that 60-day period. It's a very technical law that employers have to consider all compliance aspects carefully. One of the things that has developed during COVID is, well, what about a furlough? Or what about a temporary layoff? Does that trigger, if I'm covered by WARN, my WARN Act liability to give that notice? The layoffs under WARN, the federal WARN, have to last more than 6 months. But there's also a concept under WARN known as a rolling RIF. So you have to pay close attention to the decisions you're making as an employer in regard to RIFs and whether or not you're reaching the thresholds under WARN. But if it's a short-term furlough that's not longer than 6 months, you don't trigger liability. If it's longer than 6 months, the DOL has put out guidance that you may fall under the unforeseeable business circumstances exception to those 60-day WARN Act notice. However, you still have to give notice and you have to do it as soon as possible. So it doesn't excuse your liability for not giving notice. You still have to do it, and you should explain why. Obviously, you did not comply with the full 60-day notice requirement. So WARN has been a topic in compliance there. And a new law that's on the horizon for employers here in Maryland is the now mandatory Economic Stabilization Act. It was a voluntary law that asked employers to give 90 days notice if there was going to be a layoff of a certain size. Effective October 1, that is now mandatory. And it's mandatory in a lot of different ways. It affects employers with at least 50 employees. If there's a reduction in operations that impacts that relocates a part of the business or part of the operation from one site to another that then causes a reduction in force, or it shuts down the workplace or a portion of that operation, like a department in the facility, that actually reduces the number of employees by the greater of at least 25% or 15 employees over any 3-month period. So the criteria is different than the Federal WARN Act. It covers more employers. So as of October 1, Maryland employers are now going to have a mandatory WARN-like Act notice requirement. The one thing we're waiting anxiously for there is DOL guidance. And by the way, it is a 60-day notice requirement before the reduction date. There's civil fines of $10,000 per day for violations under the law. But the law does direct the Maryland Secretary of Labor to issue guidance with respect to things like continuation of benefits, health, pension, and severance payments as a result of reduction in force. We have not seen that guidance yet, but we are anxiously awaiting to see what's going to happen because the state of New Jersey recently amended their WARN Act, and it now provides for severance payments. Employers are required to actually make severance payments under the New Jersey mini WARN. Along with all of that, if you are going to provide severance, there are other requirements, notice and disclosures that employers have to comply with, and that relates to the Older Workers Benefit Protection Act, another very technical law. I definitely won't go into the details of that. The analysis is pretty nuanced. But generally, the waiver for 40 and older folks has to be knowing and voluntary. You have to disclose certain information about how you selected folks, who was selected by age, in order to make it a valid waiver and release of claims if you are asking 40 and older workers to sign a waiver and release for severance. So that's also a very technical law that's easy to get wrong. And we obviously help employers through that to make sure they're in compliance with the technical requirements. But to the leave situation and a little bit of unemployment, you probably know that SB 1080 was signed by the governor here in Maryland back in March. That provides extended, or I guess enhanced, unemployment benefits for COVID-related reasons. That law is in effect until April 30, 2021. And what was interesting about that expansion is that workers who are impacted by COVID in the workplace, either their business shuts down or they're quarantined due to COVID, or maybe they have a family member that they have to care for due to COVID, and they become unemployed because of those reasons, they do not have to show the state that they're actively seeking work and applying for work. So that relieved employees of that obligation here in Maryland. And that, unless the legislative body acts, that will sunset April 30, 2021. And then finally, just a quick note on leave rights expansion. So we all know about the FFCRA, the federal law that provides for emergency paid sick leave and expanded FMLA rights. That covers employers with less than 500 employees. And what I found most interesting about that law, and what some of my clients were struggling with, is employers who had less than 50 and who had never in their lives dealt with the FMLA now had to provide FMLA leave rights to employees under the FFCRA, and not just the rights, but paid leave rights. So that was a very new experience for a number of my clients in terms of compliance. How do I deal with this? What am I doing about all that? So that has definitely been a topic of the day, making sure people get their rights under those laws, as well as making sure, you know, my clients and employers are complying. Maryland has not expanded leave rights under the Healthy Working Families Act. That has sort of been the same. But I note that Montgomery County's sick and safe leave law does have pandemic-like reasons under that law for which employees can use that sick and safe, those sick and safe rights. And then a lot of other jurisdictions, including DC, have enhanced COVID leave protections. The DC has two. One is called COVID leave. It was an amendment to the DC FMLA, and provides for 16 weeks of COVID-related leave. That is unpaid leave, and that lasts as long as the mayor's order. And similar to the federal emergency paid sick leave law, they in DC offer an additional 80 hours of paid sick leave for the same reasons as under the federal law. So those are sort of temporary provisions that'll be in place while the mayor's public health order is hanging, you know, around in DC. Right now, they're set to expire August 25th. So there's I know I probably overused my time, but there's an awful lot going on in that world that, from a benefits integration standpoint and a compliance standpoint, employers, you know, are dealing with on a day-to-day basis. And I know in my lifetime, you know, in both my HR career and law, I've never quite seen anything like it. And it's been quite the challenge for employers.
Thank you so much, Ms. Glover, for that very informative explanation. We may come back to you and learn even more, but for now, you know, as time permits, we do have a Q&A question, but I want to reserve on that, though I appreciate that question. It's about Americans with Disabilities Act, and we will get to it, but I want to make sure all our panelists get a chance to speak. So I'll turn the floor over to Professor Modesitt on what's going on with whistleblowing during this COVID crisis. Please.
Thank you, Professor Hayes. Before I get to whistleblowing, I do want to take a step back and talk generally about safety and health standards so that we're all on the same page. Because one of the things that's been really difficult for employers and employees in this time has been really a lack of clear guidance on what has to happen in the workplace in order for the workplace to be safe for all of our workers. And part of the problem with that has been that the federal agency that's tasked with handling workplace health and safety, OSHA, has not issued mandatory guidance on this. They have issued suggested guidance as to what employers can do, nothing that is legally binding on employers. And so what that has done has been to create sort of a vacuum, this area where employers don't know what to do and employees really don't know what their rights are in the workplace. The guidance they've provided has also been extremely vague. So to give you an example, if you're an employee in what's called a mid-risk, a middle risk, or moderate risk workplace, the guidance they're providing to employers is that they may need to provide personal protective equipment in the workplace, but they leave it entirely vague as to what would be required specifically. Do you require respirators? Do you require masks? All of those details are not present. So it does create kind of a problem in the workplace for employers and employees not knowing what is required. We have had tons of issues with health and safety issues in the workplace in this era. It's all unknown. And we've seen as a result of that a significant uptick in the number of health and safety complaints that have been made. So earlier today when I checked OSHA's website, as of now we have approximately 7,300 health or safety complaints that have been made to OSHA that are related to the coronavirus. That's just a huge number relative to the amount of complaints that they get on an annualized basis when you think about it all being on this one topic. So what is OSHA doing about it? The answer to that is really at this moment in time, not very much. So of those 7,300 health or safety complaints, about 6,300 of those have been administratively closed, meaning they haven't actually been investigated, they have not actually taken action. In fact, the only action OSHA has taken so far on workplace safety or health issues has been to issue 2 citations. One was a record-keeping violation, which is not terribly helpful for workers, and the second was actually a violation of the safety and health standards dealing with when you have to wear masks in a nursing home. And they did issue citations to one nursing home a few days ago, citing them for failing to provide sufficient personal protective equipment and also failing to properly train workers on that. So OSHA at this moment in time is really not stepping up and doing what it needs to be doing, which means that the burden on maintaining a safe workforce is left to the employer and the employee to sort out in most instances. Ms. Chu mentioned workplaces that are unionized, but the reality is that 90% of American workers or more are not in a unionized environment. And so what that means is there's a lot of pressure put on individual workers to try and ensure that they stay safe. And that's led to an uptick in employees voicing concerns directly to their employer and employees voicing concerns directly to the media. I'm sure we've all seen these accounts in the media of nurses, of doctors coming forward and saying, I don't have the personal protective equipment that I need. These doctors and nurses are being forced into a position where they're willingly or unwillingly becoming essentially whistleblowers, coming forward and saying, look, we have a problem in the workplace and it's not being resolved. Even when I speak to management about it, it's still not being resolved. And the result of those kinds of complaints is unfortunately frequently not good for the individual employee. Because as you might guess, when an employer hears that they have a worker who has been raising these kinds of issues, the tendency is frequently not to react positively, especially if it gets a lot of media attention. Earlier this spring, there was an instance involving Amazon warehouse workers who were concerned about conditions in the warehouse, and it became highly publicized, and 4 of those workers were fired. It ultimately led to a vice president resigning in protest over the firing of those workers that had raised the safety concerns. Which is great if you're the vice president, but not so great when you are the individual who had no choice in the matter and ended up being fired. Which brings me then to what do we do about these kinds of individuals who are sacrificing their livelihoods in order to bring these kinds of concerns forward? And the answer is that there's limited protections for them in the law. So the way the system works right now, there's no federal law that says if you blow the whistle on poor workplace health or safety, you're automatically covered and protected against retaliation. Instead, there are limited protections. So there is a federal law that protects employees who bring forth health and safety concerns to their employer if it's a violation of the federal workplace health and safety standards, which are under the OSHA Act, Occupational Safety and Health Act. The problem with that law is twofold. First off, it only covers situations where there's a violation or a reasonable belief in a violation of a particular OSHA standard. And that's difficult in these days when there's no OSHA standard that is specified. So then on top of that, even if you could articulate it, your only right is to bring your claim to OSHA. And the problem with that is, as you might imagine, OSHA is overwhelmed with these kinds of complaints. All of fiscal year 2019, they had approximately 2,000 whistleblower complaints. Already, since the coronavirus began, they have more than 2,200 whistleblower complaints that are related solely to the coronavirus. So they are swamped with these kinds of complaints. As with their regular health and safety complaints, they've been administratively closing most of them. So more than half of them have been administratively closed. Only 109 have had investigations that have occurred. And there have been, to my knowledge, no citations issued on those coronavirus retaliation claims. So you don't have much protection if you're looking at it from federal law. There is some limited protection for employees depending on what state you're in. Most people here, I think, are more interested in Maryland. As many of you know, Maryland does not really offer much in the way of protection to employees who engage in whistleblowing behavior. And that's fairly typical. Only about half of the states provide protections to employees who are whistleblowers. And even in those states that do, the coronavirus situation is not really amenable to those types of protections, because the norm is an employee has to complain about a violation of the law. As I mentioned before, we don't really have laws about what employers have to do in the workplace in order to comport with health and safety standards, because this is so novel. So unless you're in Virginia, which is the first state that has created regulations that are mandatory that say employers must engage in the following actions, there's no law that has clearly been violated in many of these cases. So again, at a bit of a loss for most of these employees in terms of having any legal protections whatsoever. Which leaves them in a bit of a conundrum, which is that you have to make a decision if you're one of these employees. Is it worth it to speak up in these circumstances? If you don't have a union that is backing you, if you don't have someone who can speak on your behalf, you are putting your livelihood on the line by saying, wait, I think that the conditions that I'm working in are dangerous. And as Governor Hogan mentioned in his news conference today, one of the biggest upticks is in workplaces that we wouldn't think of as being dangerous, regular office environments, which are having higher positive rates than employees in restaurants. So the places we think of as maybe not having as high risk do in fact have high risks, and we're asking these individual employees an awful lot to be putting themselves on the line in these kinds of situations. Professor Hayes, I know we want to get to questions, so I'm going to stop there and let us get to
Terrific.
some follow-up questions.
Thank you very much, Professor Madison. We did have that one question on Q&A, and am I seeing all the questions there are, or are there other questions? I'll read the question that's on Q&A, and anybody can take a shot at it. It mentions beyond the standard concerns of safety and health, and certainly I invite other attendees now to start asking questions, because we're going to wrap this up before 6 o'clock. But beyond the standard concerns, individuals with disabilities seem to have been impacted more than the general able population. This is the underlying conditions issue that puts them in the high risk category. And so, and perhaps you've been asked about this, anybody, any of the panelists might have been asked about this. What about Americans with Disabilities Act accommodations? Is underlying conditions from COVID, is that going to meet the definition of disability? And can they demand reasonable accommodation for, and what we're also finding out, unfortunately, is COVID has long-term impact, and it can damage organs for the rest of your life. So are there going to be Americans with Disabilities Act issues that employers have to deal with from that situation? Anybody want to take that?
Well, Donna, I'm sure you have some things you'd want to say about that, and I'm happy to jump in.
I'll follow you, Taryn. You want to go first?
Yeah, I mean, there's a lot you can say here, but I think the one thing is that the EEOC has stressed and continue to stress that engaging in that accommodation process and discussion about the needs of those that are returning to work that may be high risk or have some underlying condition needs to be part of your process. So I can say, for example, in my workplace, when they decided to return to office, we did a survey to ask folks, what are you in one of those risk groups? Are you, for myself, I'm pregnant, what does that mean versus someone who may have asthma or some other medical condition? That is definitely something that you need to take into consideration. when you're returning to the office, or quite frankly, if someone has symptoms or goes out because they do have COVID and they develop symptoms. I've always been of the mindset that with the ADA, you err on the side of caution and just assume that it's a disability that's protected under the ADA and that you engage in that conversation. But I think one thing that the EOC says, and I think is important to remember, is we don't want to treat people differently just because we may think or assume that they are in a high risk category. They need to be able to make that decision. So if we're returning to work and there's a 65-year-old cancer survivor that wants to return to the office and they haven't identified that they need an accommodation, one being maybe to continue to work remotely, we can't then unilaterally say, well, you're high risk, so you need to stay home. And so I think sometimes employers may think that they're trying to be helpful by helping to make those decisions for those individuals, but that's not really their place to do that. Their place is to evaluate and figure out how to safely reopen the office and determine the individuals that are ready to return, and for those that aren't, to work through that accommodation process. And so I hope that kind of answers it, and I'll let Donna jump in to see if there's anything to
Or
add.
any of the panelists, if any other panelists want to add to that,
yes,
please do.
exactly.
We do have a second
Yeah, I'll
question.
just say
Please.
two quick things from my end. Taryn referred to the EEOC's technical guidance. They've done two key things in that guidance with respect to ADA accommodations. And I think, Maryland, the MCCR would look to that technical guidance to figure it out under state law as well. But a key point that Taryn made was you cannot push workers out of the workplace if they have disabilities, right? We can't make those assumptions or regard people as not being able to come in to the workplace because of COVID. And surveys are great, confidential surveys that only HR has eyes on, to figure out if there are underlying conditions as you start to bring people back into the workplace, then key, as the EOC has said, engage in that process. What can you do to get the worker back in the workplace first and foremost, because that's the idea under the ADA. We want you to come on in and do your job with or without accommodation. Can we figure that out to make the worker feel safe? Maybe a separate office space or plexiglass or whatever. And if we can't, and telework isn't available, then let's look at other options and what are the accommodation obligations under the ADA, and the interactive process is critical in that. In other words, long story short, employers should not just say no and either keep people out of the workplace or not engage in those types of discussions with workers to figure it out.
Any other panelists want to speak on that? And I'll go on to the second question, which is really about, and it's been much in the news this week because it's in the Senate bill. I'll read it. Could the panel please speak to legislation? And some states have passed this, not Maryland, of course. Legislature's been out of session in Maryland. But the state level and federal level of broad immunity, liability protection for employers against any coronavirus related claims from employees. What are the issues going to be with that? Some of them use the term gross negligence. How is that going to be defined? And if anybody, you're kind of grasping the, a tricky question here. My answer is next week, a week from today, is the discussion of a different panel on coronavirus litigation. So that'll, if you're interested in that issue, I certainly encourage you to attend next week's webinar as well. And secondly, workers' compensation, as I see it, and other people I'll throw into the mix here, I don't know if there have been any decisions. The Maryland Department of Labor seems to be so focused on getting out the unemployment insurance benefits. And I haven't seen that many decisions. And even if there are decisions, the key issue is going to be causation, I think. And can you prove that it was caused in the workplace? And then will the Maryland legislature do something to make that easier? So these are all free-floating questions that are out there. So I've said my 2 cents. What do other panelists think?
Mike, Professor Hayes, let me jump in on the workers' comp. There have been a couple of states that have moved in this direction legislatively and created a presumption that if
Right, I'm sorry,
in
yes.
the workplace, and that makes it easy for these employees to get workers' compensation, which is
California did that, I think.
right. And a couple of, I think Illinois might have just done
Maybe
it too.
Illinois. Yeah.
Illinois did it, but then they pulled it back.
Oh, Illinois did and then pulled it. Oh, thank you, Jessica.
Yeah.
So it's been interesting. I mean, I think that that's one of the interesting ways to do this is to simply say, let's not make it an all or nothing. Let's put it to workers' comp, which is sort of that middle ground between real litigation and employee compensation.
Thank you. Any other panelists want to speak on, will workers be able to sue anybody? I guess is kind of the
No,
the
I would say
question.
the only thing I would add to that is I think at least that I see from my perspective is you're right. The workers' comp piece is another piece, and what it seems that flows from that is then someone's filing the GL claim, the personal injury claim, the general liability claim, and
Right.
it you know, we still don't know what that looks like, and I think that goes back to my earlier point that I think employers aren't getting a lot of guidance from the government about what is they should or should not do, and so they are doing what they think is best, and in some cases is let's just COVID test everyone, and if we check that box, then maybe we're covered. And so I think it remains to be seen, you know, as different clients in different industries go about it different ways in terms of creating a safe return to work protocol and a safe work environment, what really holds up as a good defense to say, I did what I was supposed to. I met the standard of care. I created a safe work environment, because I really do think in a way, like everyone's just doing what they think is best. And some of it creates, and I'm sure Jessica can say, creates challenges sometimes for employees when they say, you know, you need to get 2 COVID tests to come in. Well, everyone knows you can't, you know, COVID tests. I'm like, no one's just sitting here with a box of COVID tests, just sitting here waiting to be used. I mean, they're in limited supply. And so really trying to figure out, and maybe that's why CDC has probably moved their guidance so much away from testing and more to a symptom-based strategy. But really, I feel like that's where the challenge and probably the frustration is on the employer and employee side,
No,
in
thank
terms
you.
of
Yeah.
what really is required and how that will shake out in terms of when people, you know, start to litigate those issues.
And we have one more question. I'd like to end with this one more question, which does raise that a lot of the employees who are considered essential, it's disproportionately women, it's disproportionately African-American or other or people of color. And if anyone wanted to say anything about that, you know, again, that could be bases for lawsuits too, both state and federal possibly. So if anyone wanted to address that question, that's the third question, which is, you know, home health aides, caregiving obligations, which are disproportionately women. What are the gender and racial justice implications, I guess, is how I'd sum up that question. And we only have a couple minutes, so if anyone has something quick they want to say about that, it's a big topic, I realize.
A couple minutes definitely won't do it for that
No, a
topic.
couple minutes wouldn't do it, I'm
But
afraid.
I will say one thing is that, which
Please.
is there were some interesting articles out recently about the disproportionate effect on caregivers, and how they are likely to lose out when they are subject to the reductions in force that Donna was talking about. It's sort of the worst of all worlds. You're doing double work and then you get fired for it.
And I'll say one other thing, Professor. You know, under the FFCRA, healthcare employers have an opt-out of that law. So even if you're under 500, you can announce to your workers that you're not covered because we're taking advantage of the exemption under that law. So, and many, many, many healthcare providers did that from the get-go. And so those employees also didn't have those leave rights, those federal leave rights, if they, you know, were at an under 500 employer. So it's really been quite a challenge for those workers.
Jessica, did you want to, I don't mean to put you on the spot, but you haven't said anything for a while. I just wanted to ask if you had anything to say in closing, or if anybody else had anything to say in closing. I'll start with you.
Specific to the question or in general?
No, just generally. We've got a minute to go, so anything you want to say.
No, not really. But I'd be happy to follow up with anybody individually. If you can provide my email address, I'd be happy to do that.
Yeah, thanks for that. Anybody else have anything they wanted? Well, thank you all very much. I want to thank each of our panelists, Jessica Chu, Donna Glover, Taryn Butcher, and Nancy Modisette. I know they're all very busy. I also want to thank Mr. Cooper Jarris, who provides student assistance on this, Law School Communications Director Christine Stutz, who helped promote it and has been vital with this webinar, also Alumni Engagement Director Jason Keller. And finally, we couldn't do this without Mr. Jared Schuster from the University of Baltimore's Office of Technology Services. So thanks very much to him. And thank you to all of the attendees and anybody who might watch this in the future. And with that, we conclude our webinar.